All rise. Judge of the B Court is now in session. Judge's case number JVB 1039, Sutton case.
Thank you.
You're welcome.
Okay, Ms. Sultan, you're back. And I see that you got, well, dad or potential father. Sir, what's your name, sir?
My name is Stephen Pippin.
Mr. Pippin. Okay, you understand why you are here today, right?
Yeah, unfortunately.
Okay, you know I ordered you to have DNA testing done a month ago.
Yes.
And so we can determine child support, what it's going to be in this case. And I don't have anything from the testing center showing that you showed up. So what's going on with that?
Because I didn't take it. I mean, I don't know what she's talking about.
So I order you to do something. This is not about her right now. I order you to do something and you just decide on your own, I'm not going to do it.
Yeah, I mean, I don't think I'm the father, so I don't have to take the DNA.
Welcome back to another compelling case in child support court. Miss Olin returns with Mr. Stephen Pittman, who she identifies as the possible father of her child. The judge immediately addresses a pressing issue, Mr. Pittman's failure to comply with a DNA test that was ordered a month earlier. Mr. Pittman explains that his schedule prevented him from completing it and expresses doubts about being the biological father. With the matter unresolved, the judge prepares to address the situation in accordance with the law. Let's follow how this case develops.
If you don't think you're the father, wouldn't it make sense to go ahead and take the DNA test?
Yeah, but I mean, it's all this long process. I'm a busy man. I got a lot of stuff on my plate right now, so I don't have time to sit back and
Well, how busy are you? What do you do?
I'm a waiter.
Oh.
And I'm a full-time student.
Oh, okay.
So I don't have time for the games and all this testing, DNA testing, all that. I don't have time for it.
All right, so you work every day as a waiter?
Yes.
Did you bring anything today to show that you're waiting tables? Any type of financial information?
I ain't bring that.
Oh, so you didn't care about that either. So did you bring anything to show that you're enrolled as a full-time student?
Nah, I ain't bring none of that.
So you just came to court unprepared today and you just think I should go along with that, right?
If that's what you want to call unprepared, yeah.
When did you start working as a waiter?
About 4 months ago.
What did you do 4 months ago?
I had a full-time job working as a consultant.
All right. How much money were you making?
$63,000.
Hold on. How did you say your baby was?
5 months.
5 months. And you just stopped working there 4 months ago?
Yeah, they had some layoffs, and I kind of thought that they were going to start laying some people off, so I decided to go ahead and quit.
So you quit?
Mm-hmm.
You didn't quit because you figured she was probably going to put you on child support?
Nah, I just...
Are you sure about that? Because it's mighty funny that this child is 5 months old and you just stopped working that job 4 months ago. How much money were you making?
$63,000.
$63,000 a year? And you're making how much as a waiter?
I did it because I'm a student, so I'll probably make around $15 an hour.
Oh, no. You came here to waste my time. You obviously came here to waste my time.
As proceedings continue, Mr. Pittman provides his explanation for not completing the DNA test, stating he is balancing work as a waiter and full-time studies. However, he is unable to produce documentation confirming either role. The judge takes note of this and becomes increasingly concerned when it is revealed that Mr. Pittman left a well-paying job just 4 months prior. The court begins to assess whether these choices may be impacting his level of responsibility in this matter.
I am not going to place you on child support for $15 an hour and you just start working a job paying you $63,000 a year. You see how crazy that sounds?
I mean, I think it's crazy that you using my $63,000 income. I don't even work there no more.
You don't have to work there, but it sounds like you intentionally stopped working there because you thought she was going to put you on child support.
No.
So you just disappeared on her?
Because I'm not the father. Like, I don't even know. Like, I'm at work.
But we don't know that you're not the father because I ordered you to go and get DNA testing. So we could have found that out today. But you know what? We don't have to do it. You know why? Because I can deem you the father today because I ordered you to do it and you didn't do it. That's what we're going to do. That's exactly what we're going to do. So, who carries health insurance? Well, never mind. That was a bad question.
Yeah, it's me.
You carry health insurance.
Yes,
How
ma'am.
much is it?
$750.
$750. Does that include you and the child?
Yes, it does.
Okay. So what I'm going to do is split that in half, because child support, his obligation, he's only responsible to pay health insurance for the child only. Okay. So based on $63,000 a year, I have your monthly gross at $5,250. That brings your net to $4,226.99. How many other children you have? No other children?
No other children.
Well, I hope not. I hope you're not ghosting on them either, because that's exactly what you did to her. So I have your monthly child support obligation at $845 plus $375, which is half of that $750 for health insurance for the child. Your monthly obligation is $1,220.
The judge delivers a decisive response. She addresses Mr. Pittman's employment history and raises questions about the timing of his job resignation. Although he claims to be employed and pursuing education, the court determines his child support obligation based on his previous income of $63,000 annually. He is ordered to pay $1,220 each month, which includes a portion of the child's health insurance. Because he did not complete the court-ordered DNA test, the court establishes paternity by default, following legal protocol.
And I'm ordering you to do that. And you don't have any control over that, because that goes through a state agency and it'll just
I
withhold
just
from you.
go ahead and submit my W-2s whenever I get them. I'll come back.
Oh, okay, that's fine. But today, this is what we're doing. Since you came in here unprepared and not caring about anything, you don't care about that $1,220 either then, right?
Okay, I guess so. But we'll get up there. I'm not tripping.
Okay, well, we can do that at a later date. Do you have any other questions?
No, I don't got no question.
Okay, do you have any other questions? Okay, if nothing further.
Mr. Pittman expresses disagreement with the ruling, but the judge reinforces that compliance with court orders is a legal obligation. She reminds the parties that the child's well-being is the central concern, above any personal or financial challenges. The case concludes with a firm reminder that parenting involves responsibility and consistent support. The judge reflects on Texas law, which allows for legal paternity to be determined by default if a DNA test is not completed as ordered. The episode closes with a message encouraging accountability and proactive action, because each legal decision made today can shape a child's future.